you in the middle or the other way around?
I'm going to be in the middle.
You're going to be in the middle?
Well, you know what? That doesn't make any sense, does
No,
it?
because the camera will be moving.
Yeah.
I think Caplan and I should be in the middle, you guys on the sides.
Okay.
We're going to keep these guys separated? Is that the idea?
No. Caplan and I.
You go over the end, I'll go to the end.
Those guys go to the end. I think that makes more sense. We may rope you in once in a while, too.
Dog and pony?
Yeah.
And I gather we have to stop promptly at 11. At what time? 11:40.
11:40, yeah.
Because of
Yeah,
throw
lunch.
everything off.
Because lunch won't work.
Yeah, we may occasionally rope you two in, too. We're not
that's
just going to let
okay.
you sit here.
That's okay. And if you want to, get audience questions, if you have time, whatever, just make it interactive as you like. Mike, I was upset with the last sessions. It was not interactive.
Yeah, no, ours will be intensely interactive. We're actually going to comment. Each of us is going to comment on the same comment.
Why don't I just
First time I've been served.
If you have any questions, and then you can introduce. Questions, if they have questions, to leave them in the box.
Yeah.
Why not?
We're going to try. Yeah. Or we can even say during. Why not say questions and answers during? We don't care.
What's that?
If somebody wants to put up their hand, we'll just take the question right then and there. It's more spontaneous.
Yeah, but remember, you've got to repeat the question.
Yeah, fine. You'll remind us.
Howie, they'll do spontaneous questions.
Sorry?
They'll do spontaneous
Yeah, if they have
questions in the
something, just
audience,
ask
so
us.
you'll stop.
Yeah, we want them to have.
Yeah, we'll just do it not at the end, just in between.
Well, what do you want?
Yeah, that's what I prefer.
During is
Because
fine.
people never remember the questions. They're intimidated.
Although-
They have a question.
I will say that to them.
If you want to start and invite people, so you want me to start?
Although we may lose the drift of it.
No, won't. I won't.
Welcome back. It actually worked. If you have any questions generally for the senior practitioner or the judges panel, you see the box that says deposit questions here. That's exactly what it means. But for this particular session, if you have any questions, just interrupt. These guys are good on their feet. And I'm quite serious about that. They're prepared to take questions at any given point through their session. Barry Fisher is my family mediator. He did my brother-in-law's dispute, and in a recent case where I am the plaintiff, non-employment law related, he was my mediator.
I can assure you that must have taken an incredible amount of work.
Did it, Barry?
Put it this way, we had Chinese food at 2:30 in the morning.
Barry's the publisher of the database, and he is also the first to leave our respective bar, albeit to another portion of our respective bar, now doing human resource mediation. And in that respect, people go to Barry when they want someone who really knows his stuff in the workplace law area. Barry and I had our own mediation very early in our lives. We were both young, aggressive, and didn't seem to get along very well at our respective cases. And I don't know how many of you remember Deborah Sward, who may still be around. I haven't seen her in a few years, who was with the, what was it called? The
ADR Center.
The ADR Center. And about our second case that you guys need some mediation, and she took us out for lunch one day at her expense, and we've been good friends ever since. So maybe that's what let Barry know that mediation isn't such a bad thing. Gary Caplan was my opponent in the case before Justice Echlin last week. And in his decision, he said, I don't think there's any realistic prospect that this case will settle. But as I mentioned earlier, Randy put such incentives to settlement into the judgment that Gary let me know that yesterday the parties settled the case for 1 additional month severance pay.
The parties, the lawyers had nothing to do with it? Is that what you're telling us?
Right. I first knew Gary at law school, and the next I heard of him was a few years later, where various people told me he had become one of the best litigators in this province. As constant with that, he teaches ADR and civil litigation at Osgoode Hall Law School, and my experience is, if you want someone who cuts through the crap and has, particularly in a rights-based mediation, is able to go to the other side in caucus and tell them all the things that are wrong with their case that they haven't figured out yet, Gary is a very good choice. So start being interactive.
All right.
All right, you have copies of our papers, the Barry and Gary Show. Barry's paper is very practical. I urge you to read it. There's some wonderful tips in there, and you'll, I think you'll profit by it. My paper is on a different trajectory. It's philosophy-based, and it asks you the question, what kind of justice are you achieving in a mediation, particularly in an employment law mediation? So read them, you'll get a giggle out of them maybe, and some practical tips. But what we're going to do today is we're going to have an interactive panel discussion. We have a number of topics. What we're going to discuss is what works, what doesn't work for us as mediators in an employment dispute mediation. And we have a number of topics that we picked out. Barry, why don't you lead off with the first one?
All right. The real topic heading is, he doesn't want to read it, what pisses us off and what do we like at mediation. Number one on my list of things that I don't like or like, depending on what you do, and this is typically a defendant issue, although it can affect the plaintiff, is lack of authority. The single most, probably the main reason mediations fail, and I use that word, do not result in a settlement, is because the proper people are not in the room. And there's an age-old problem here. I mean, and I can sort of predict that the usual characters that show up at a mediation, you got the HR person, you always have outside counsel, of course. You have in-house counsel often, especially if it's an American outfit. You then often have the direct supervisor, and none of those people generally have enough power to make a decision, with some exceptions. More often than not, or not enough times, the decision maker, i.e. the person who can write the check, doesn't show up. And that's a huge continuing problem in mediation. And whether the person's on the phone or whatever, none of it's as good, especially when the person's on the phone. And I don't know, somebody maybe in confidence can tell me this is true, I think it probably is, that the defense counsel intentionally leave the decision maker at home. And what they then do is what I call prepare the Wizard of Oz complex, which is the wizard is at home, and the wizard could be like on the floor below me or whatever, and the mediator's not allowed to talk to the wizard. Everyone's scared about the wizard, and all that. It is highly destructive. I should probably go back to this practice, asking in the opening session, Mr. Kuretzky, have you brought a client with you who has the authority to settle this case?
It is such a problem that, in fact, I do ask that, especially where I have a U.S. corporation, knowing that I have a local Canadian lawyer, but I know that the wizard is in New York. And what I'm often asked to do, and it puts me in a horrible position, is after the deal is almost there, then I realize, they reveal that there's not, the person who is at the mediation doesn't have the authority. They drag me into a private room, get me on the phone, long distance to some buddy in New York or Washington, and I have to sit there and defend the very deal that counsel put together. And it's completely counterproductive. Don't do it. If your counsel, as Barry says, make sure you walk in with somebody who has enough authority to cut the deal. Let's move on to the second one, which is the mediation brief that imitates the pleading. Let me be blunt. Mediation is advocacy. The statistics tell us that most employment cases do settle at mediation. If you write a miserable brief, you'll likely get a miserable result, and the mediator won't help you. Take it seriously. It is advocacy. Just don't throw in pleadings. You're going to pick mediators that have a blend of characteristics. You have the process manager type of mediator, someone who just makes sure the process works well. You have mediators who are quasi-negotiators. You've got mediators who are problem solvers. You've got the reality checkers. And you've got mediators who are picked because they're authoritarian, sometimes retired judges or very senior members of the bar. You get to pick the mediator, write a brief that fits the mediator and fits the dispute, because that's the first thing that I read, and it leaves a lasting impression, just like it would if I were sitting as an arbitrator or a trial judge. You agree with that, Barry?
Yeah, and there's, I think, five things I want to know before I want to know anything. I want to know when he was hired, I want to know when he was fired, I want to know his age, I want to know his position, and I want to know his compensation. That's my snapshot. You know, the 14th claim of intentional infliction of mental suffering, that's really important, and I'll get to it. But give me a snapshot of who that person is. And I can't tell you the number of times I read a brief and nobody tells me the person's age. And it might even be useful to give me some clue as to what the employer does. Now, if it's IBM or if it's the TTC, I got a pretty good idea. But if it's Strategic Initiatives Corporation Governance Limited, like duh, tell me. And please also tell me if they're related to anyone. I don't know how many times I've read a mediation brief and you get there and all this fascinating law and you get there and figure, oh my God, the plaintiff is the brother-in-law of the defendant. I'm like, duh. This is not a pleading. This is mediation. Tell me the human story, the human drama. Then I'll even read it.
Watch too many soap operas.
I used to read, and don't write the brief. We don't want to read the pleadings. Notwithstanding we heard this morning, pleadings are junk, who cares? Give me the story. You know, the only thing I check in the pleadings is paragraph 1A. Where can we shove some tax-free dollars? Beyond that, I don't care what the pleadings say. Tell me your story in the mediation brief. And by the way, the form they provide under the rules sucks. You don't need to use it. When I was counsel, I used to just tell a story. I'd pick it up, it looked like a letter. My guy is a 48-year-old so-and-so, he got screwed this way, blah, 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 here's his damages. And you know what, if he's got a job, like, duh, tell us, we're gonna find out.
Yeah, because we
do the damage calculation.
Remember, it's advocacy, but it's a different kind of advocacy. It's not pleadings advocacy. As Barry says, it's narrative. The plaintiff comes to a mediation with a narrative, the defendant comes with a narrative. It's a clash of narratives. It's a different kind of advocacy. You're not bound by legal norms, necessarily, and you're not bound by using legal lingo. It's a human problem. Anyway, next point.
Let me ask a question. How many of you send your own mediation brief to your client? Okay. How many of you send the other side's mediation brief to the client?
How many of you review them before going into the mediation room in depth?
So a large number of you don't send, maybe not everybody, but so just, I won't ask you to put up your hands on this one, but it sounds like a significant number of people do not send their clients either of the mediation briefs. That's not terribly surprising because one of the issues of mediation brief is who you're writing it for. So if you're writing it for I'm assuming you're writing it, I don't know who you're writing it for, I'm assuming you're writing it for the mediator, but you may well be writing it for other audiences. Okay. Next thing we're going to talk about is what we like, and I'm really big on this one, and anyone who's done anything with me would know that. I like what I call intellectual honesty, and I'm very upfront about using that as a criteria whereby I judge whether I can get along with this lawyer. Just like when I was in practice, and somebody would bring a statement of claim into me or something, the first thing I checked was who the lawyer is on the other side. The rest of it was really irrelevant information. That sets the tone. The first thing I do is I flip open the two briefs and see who the two lawyers are. A, to see if I know them, and if I know them, go, okay, fine, you know, oil and water or whatever. So intellectual honesty is what I call is being sort of straight. I don't expect complete and utter honesty with the mediator. And again, I don't necessarily expect this in the joint session, but certainly in the separate caucus, we're not going to get very far together if you're not intellectually straight with me. So if the notice period is 9 to 12, fine, call it 10 to 14, but don't start coming with the 24s and everything like that. It's just like you'll tune out a judge, you'll tune out a mediator. And and for all those who are out there, when I ask you what's your assessment of reasonable notice, which for those of you who do, that is actually one of my little tests for either how straight or how stupid this lawyer happens to be. And I'll do it I won't do that in joint session, but in separate caucus, and I'm saying, are you going to be straight with me or not? And if you told your client it's a 24-monther when it's really a 12, like, I need to know that. So I'm really big on intellectual honesty. Do you care if they tell you the truth?
Part of what goes on is sometimes you think you can leverage the mediator, and don't do that because most of the good mediators around know when they're being leveraged, and they won't participate in that. And I think Barry's right. I'll see it in a minute, and you're losing. Not that you lose a case, but you're basically destroying your own position right before your client, because you'll disaffect the mediator. Don't do that. Don't do that. Let's go on to the next one. If we're not being effective with the client, tell us how we can be. Now, very often in mediations and employment mediations, counsel have varying strategies. One is they have to distance themselves from their own client. They just can't bring their client on board. So they want the mediator to do some of the reality checking that the lawyer can't get the client to do. Other times they want a very evaluative mediator. We'll come hopefully later on to the different styles of mediation. And they want the mediator to effectively bring the client around to a deal. And sometimes it's the lawyer that needs to be brought around to the deal. It's the client who's desperate for a deal. And when you read my paper about justice and the marginal utility of the last dollar offered, you'll see that in employment mediation especially, that's a problem. The employee who has not had a chance to mitigate or has mitigated in a disadvantaged way has to take a deal because he or she has to take a deal. They need the money, right? And is the result, even though it's consented to at the end, is it really an effective deal? So those are some of the issues that pop into my mind about being effective. Barry, do you want to add on that one?
Yeah, what I mean by this is when I'm, what other people call beating up, I call it reality testing. When I'm having a firm discussion with your client, I'm looking very much at the lawyer when I'm doing this. I'm, in essence, looking for permission to continue doing what I'm doing. So if you don't like what I'm doing, if there's something I need to know, then express it some way. You know, like move your eyebrows or say, take a break or something like that. And then you can either say it right then or you can haul me outside and say, listen, I've told him all this, it's not working, or whatever. So that's what I mean. If we all have our little tricks of the trade. Some of them work, some of them don't. You hopefully know your client. And if it's being ineffective, tell us. We can change. We're not, it sometimes looks, well, we're always, I think, passionate. But we can switch off. We can be impassionate. We can be nice or not nice, whatever. These are all techniques.
Depending
but we
on
need your guidance.
Depending on the case, sometimes I get the parties to agree that they won't have opening statements. Why? Because they're inflammatory, and there's the lawyers end up grandstanding, and then I have to undo all that damage in caucus. And the other thing that happens with an opening statement is that the lawyer makes a thumping good opening statement and then goes into caucus and he says, well, you know, you don't have such a great case and maybe we should settle. And the client says, what are you talking about? I heard the speech from God in that room. What do you, and then the client feels abandoned. Like, what are you doing? I don't understand how that happened. You said I had a great case there and here you're telling me I don't? So in some mediations and employment cases, I ask the parties to dispense with an opening statement, and I do so where the mediation brief is poignant, it's excellent, it's good advocacy. I can skip the opening statement. On the other hand, there may be times when the employee has to vent, and therefore an opening statement can be effective as long as the other lawyer doesn't throw down the pen and threaten to walk out. Right.
I find every time I almost never suggest no opening statement, but I'll often people coming to me saying we don't want to have opening statements, they don't want to sit in the room together. And I must say every time I've acquiesced to that, and I think I have to if both lawyers want me to, I feel the mediation has lost something. So even if it is this, if nothing else, I'm watching the human behavior. I had one where the issue was, I don't know, reasonable notice, whatever, and the two people were at it for about 10 minutes over whether, when this woman got an extension to her maternity leave, she asked for it and he consented, or he asked her and she consented. It was completely irrelevant. But the two of them went at it for 5 minutes, each accusing the other one of being a rotten liar. And the lawyers are giving me like, Barry, why don't you stop giving me that eyebrow? Can't you just move on? And I just let it go on. Just watch. And I'm watching the dynamics. And then after about 5 minutes, I said, okay, fine enough. We've watched for 5 minutes you two arguing over what the rest of us in the room know is completely and entirely irrelevant. But it's given us all some insight into how incredibly dysfunctional it must have been for the two of you to work together. I think it was a constructive dismissal, so, oh, okay, so can we move on? So So I like doing that thing. Is it my turn now?
Yes, it is.
Give us some insight into your client's mind. Well, that's sort of like what I said before, but lawyers who've worked with me before know full well they'll either phone me ahead of time or pull me aside and say, listen, my client is a real ant, fill in the blank. He's really difficult this way or difficult that way, or he likes this, he doesn't like to. In other words, it's sort of what I talked about before. If I'm not being effective, give me some insight. Tell me about the human factor. That's if you've actually met your client before 9:30 in the morning of the mediation. That can be of assistance. I had one, and because sometimes we just make assumptions. I had one case where the plaintiff had a bipolar disorder. And I was told that she was very sensitive and had to be very careful, which is people saying, Barry, please don't do what you normally do. Actually try to be nice. So I was like really sensitive to that. And the employer didn't say anything. When I got to the mediation, the woman with the bipolar disorder was fine. I had an effective discussion with her. The employer was frickin' nuts. They had more psychiatric disorders than you could fill a DSM, is that what it's called? DSM Access or whatever. I should have been given a heads up on that one. So,
for me, insight into your client's mind means what your client really needs. The mediation brief speaks in the classical model of notice and responsibility and managerial, all that sort of stuff. That's nice, but what the employee plaintiff wants and needs is to get on with his or her life. What they really want is a letter of reference, something, or some payment just to get going. And the lawyers construct a wonderful case, but at the end of the day, all the plaintiff wants is something really basic. I need a good letter of reference. I don't even care about an apology. Write me that letter of reference so I can get on. So what is it the client wants? Please, before you come to mediation, ask your client what it is they need and want and why. It's their problem.
You can't get 30% off a reference letter. It's hard to get a contingency fee off a reference letter.
Maybe that's why. All right. Next. Well, this is sort of something.
Sorry, question here.
Yeah.
Gary, reference letters. They're so fraught with danger. Among other things, the employee wants to say all these nice things about the employee that really are probably not appropriate because you are letting this employee go. It's not for cause, but there have been reasons why this employee is being let go as opposed to another one. They ask you for a glowing letter of reference. If you accede to that and give it to them, they give that to the next guy. The next guy hires them on that basis and then comes after you because it was all BS. How do you rationalize?
Because
You gotta repeat the question.
Oh, sorry. In a nutshell, the question was negotiating over a reference letter has inherent dangers to it, and how does it really affect or add to the resolution of the problem? It seems to create more problems than it solves. And it's a very good point. The problem is that the mediation then shifts to the reference letter. You end up mediating the contents of a reference letter. And I've done that in many employment disputes, where at the end of it, we end up working on the reference letter, and both parties, and a skillful mediator will be able to assist in crafting one that is not misleading, is factual, truthful, but gets the employee what the employee needs to get on with it. And I agree with you. It raises dangers, but use the mediator. Don't say, okay, it's a reference letter and walk out. That's what the mediator is there to help you do.
What I do is I assign that job of the drafting to the plaintiff. And you'd be surprised. Most plaintiffs, we're Canadians, we're usually modest. Most people will not go overboard. And I suggest to them, have the first paragraph say you were here from here to this date, and you had these various jobs. And then reference objective stuff. If there's a performance review, refer to back in 1962. He was found to be a very competent employee. He was born in 1963, but had he lived. Reference that using adjectives and verbs. He participated in a sales drive. Yeah, he slugged boxes and the rest of the company did well. So you can adjust little words that make it sound really nice. So you can always, it goes back to what your mother said, or maybe not, depends on who your mother was. You can always say something nice about somebody. That's all they need. It's extremely important to the plaintiff's psyche. In the real world, it doesn't matter very much. And when I hear employers say, it's not our policy to give it, and how could I do that? And I think, oh God, I say, fine, pay him 10,000 more bucks, fine, where can I sign the letter? You know, it costs nothing. It makes the plaintiff feel good. Why not, I say. But you're right, I spend like hours at 500 bucks an hour, it's great, arguing over a reference letter.
Remember, in a mediation, the plaintiff, the defendant has an early opportunity to buy the plaintiff's rights. That's what's happening. It's a marketplace. The defendant employer can buy certainty with a one-time payment of a check. But the plaintiff may not, the money may not be what the plaintiff really needs. And you've got to be creative in coming up with other ways of resolving it.
I had I'll just tell you about the drama of it. Now, this was actually an apology letter, which I'd never seen, but boy, this guy was entitled to it. He had been falsely accused of something. The cops came, they charged them, charges dismissed and everything. And it was ridiculous. The company was just totally wrong. And defense counsel knew that. Luckily, of course, everybody on the defense team was 5 years later. They weren't responsible for any of the mistakes, so it was easy for them to apologize because they were apologizing for people who had left the company. But defense counsel said, I asked her to do an apology. She said, fine. Normally, I leave letters of recommendation and reference letters after the money's been settled. But in this case, defense counsel drafted an apology. It was an excellent apology. And before the money was settled, I brought it in, and I went to the plaintiff and I said, here's the letter the company is giving you, not prepared to give you, is giving you, whether this deal settles or not. He then spent the rest of the mediation just looking at it, almost tearful. And so was plaintiff's counsel because the monetary request kept on going down. He was in the bag already. Oh, my lawyer will talk about the money. That's nice. It was beautiful.
Another kind of letter you should consider in mediation is an acknowledgement letter, not an apology. In a case I had involving departing employees who were then sued by the employer, alleging, the usual stole confidential materials, and basically they went into competition with their former employer. What I realized at the end of the mediation is what the employer wanted and was worried about was the precedential value of paying these people off to get rid of them or some judgment. So at the end, it settled for no money, but the departing employees simply wrote a letter acknowledging that their employment contracts, which contained the non-compete, non-solicit, the usual bump and grind, were valid. So the employer could then take that acknowledgement letter and circulate it among his workers and say, you see, the contract works. And by the way, don't leave or else I'll see you in court too. But that whole case settled for no money. Another effective way of dealing with it. Let's move on.
We have 12 minutes.
Really?
Do you want to go to evaluative?
Sure, let's do that.
Okay.
Okay.
Both of us, if you want a facilitative, caring, kumbaya mediator, don't call us. That's what somebody actually said. I came in and I guess I was getting a little soft. I said, what is this? They said, is this kumbaya time? So that's my expression. But evaluative mediators, especially among non-evaluative mediators, have a bad name. I think it's mostly jealousy over the amount of work evaluative mediators get. But we want to talk a little bit about what does evaluative mediation mean and different techniques in doing it. So some of this is like mediation terminology. Classic mediation training tells us that we are never to express an opinion about anything. There was even, somebody once told me, I guess a mediator who really took the non-evaluative component seriously, when told by defense counsel to go deliver this offer, they said, no, that's not my job. I'm not to communicate offers. So, well, what are you supposed to do? Just process. So we're not like that. But one issue is, when are you evaluative? When are you evaluative? When are you not?
I have in employment disputes, and depending on the nature of the dispute, if it's a poisoned workplace, I have one strategy. If it's simply the bump and grind kind of notice and how much is that, that's another kind of strategy. But sometimes what I do is the outer extreme of when I'm evaluative is I tell them with their consent that I'm going to hear what they have to say. I'm going to put them through an exercise whereby they switch roles. I actually asked the employer to play the role of the employee, and I asked the employee to pretend he is the employer, given the fact situation. In caucus, separately, I have them do a risk analysis of the other side. And I asked them to tell me what they would settle for if they were on the other side. And then I go back and I tell them what the deal is. I tell them what I think is reasonable. 99 times out of 100, they accept. Why? Because they don't realize they've told me what the risks are. They've told me what the deal is. I've just used words to show them the other side of the case, something they weren't sensitive to coming in. That is the ultra extreme of when I'm extremely evaluative, and they like that. It gets rid of the, being at the factory Saturday morning fighting over a coat. You start high, you start low, and somewhere you cut to the middle. Forget it. Let the mediator tell you what is fair. That's a very extreme approach, and I don't do it unless I have consent. And then there's the other ones where, as Barry says, you're more risk reality checking. Have you really thought about this? Why don't you think about that? Where are you going with this? And we tend to, I suspect, be evaluative at different times. At first, we may start off facilitative and looking hard at the risks. But if the parties aren't moving or the lawyers aren't moving, we take out the heavy lumber. The 2x4s come out at the end in order to make them really see where they're going with this thing.
I think that evaluative technique is a question of subtlety, and it can start at the very beginning. I could, when I do a mediation opening, I not only give the spiel, my own little spiel, but I summarize what I've picked up from reading the briefs. And often, depending on the lawyers and stuff like that, I may even turn and say, Mr. Kuretzky, for mediation purposes, are we going to be talking about just cause? Oh, yes, absolutely. No, not really. We'll park that issue. So that's a very, I don't know how subtle it is, but that's an evaluative technique, even in the joint session.
And remember this, mediation, especially early mediations, you're front-end loading your file. You're front-end loading your file. The case will likely settle, so do the work that you would have done had you not had the mediation. Do your factual investigation. Get your witness statements. Ask for the employment file. Do not go into a mediation unless you've got the affidavits of documents. Why are you settling in the dark? Yeah.
The question is, if the employer is alleging cause, how can you get them to park cause? My point is, there's allegations and there's real stuff and there's junk. And what I'm trying to do in a mediation is get rid of the junk. So I would only make a comment like that if I felt, and I know the lawyer and I can read the brief, that maybe cause is junk. So it's my way of being evaluative in the very beginning and saying, oh, well, we'll park that for now. For mediation purposes, we're prepared to talk about this is not cause, blah, blah, blah. And I may then get I sort of get a similar concession out of the plaintiff saying, I take it the core issue is reasonable notice, and not every tort you read about in Lawyers Weekly last week. And typically in those highly adversarial things, there's a core issue and everyone adds junk. And just cause is simply one of the items that is often added, not always, often added as junk, just like all the torts are. So part of my job is to try to peel both of them away and come down to the real issue, especially after acquired cause or something.
But we can only do with the material we have before you. If you haven't done the work to get the file into a negotiable state, the mediation will fail because the settlement DNA is not there. So make sure, as I'm repeating myself, ask for and obtain a sworn affidavit of documents so you're not settling, God forbid, in the dark. You've missed something. And do as much of the investigation work that you can, even though it's well before discoveries. And make sure the file is well organized and prepared so that we can do a proper evaluation. Because a lot of these cases fail because it's too early in many ways. And that's something one of you raised earlier with Justice Echlin.
I disagree with what he said. I would say 90% of the mediations I do, people don't have affidavit of documents.
And that's, I think, is wrong.
Most of the affidavit documents junk. There's usually 2 or 3. is 2 or 3 good documents. The rest of it is all the crap. 5 years ago, he asked for a day off to visit his grandmother. I don't need to see that stuff. And it's just thicker. I disagree with this. I think that one of the reasons people settle at mediation is they don't want to work. They don't want to do the prep.
Well, how are you
so I take advantage of that.
Well, how are you treating the mediation? Is the mediation an accurate predictor of a trial result? Or are you settling because it's so uncertain, nobody wants to take the risk?
No, because it's a $25,000 case, and you can't afford to do $12,000 of workup to settle the case for $20,000.
Well, that's
it's a
right.
law of diminishing returns.
Well, then make sure
do a really good interview, get the key documents, and go for it.
And then
you're going to spend 90% of your energy getting another $5,000.
And tell your client that.
Yeah, whatever.
Because
the
if
client
your
cares.
because if the
doing a crap job, I'll get more money for you.
Because if the employer walks out and says, and here's the document that would have killed your case or made your case, whatever, and ha ha ha, and the deal's signed, and the lawyer and the client turns to the lawyer and says, why didn't we have that document in advance? Call LPIC.
I had one the other day where the employer was not satisfied that the evidence of psychiatric disorder was adequate and wanted an adjournment so they could get more. And I said, he's probably not, right now he's got a lousy report and he didn't pay anything for it. You're about to tell him to go get a good report, which will improve his case. Oh, yeah, okay, so we went back to settle. So I take advantage of, I don't call it laziness, I was plaintiff's counsel. You can't afford to do a Cadillac for a Ford.
You don't have to do a Cadillac, but what you can do is make sure that you haven't missed the silver bullet or the smoking gun.
I think at this point, Howard and I are going to do some mediation.
Good idea.
Okay.
Sharon had a question.
Sharon had a question.
This only happens to me only happens from time to time with non-employment bar litigators. But what do you do in a situation where the mediation is being used as an excuse for examination, for discovery? How do you handle that?
I can tell you,
The question is,
right.
what do you do when the mediation appears to be nothing more than an excuse by the other lawyer to have a free examination for discovery?
There are 2 ways I handle that. First of all, I make it clear at the outset that the mediation will not be used as an examination for discovery, and if it is, I will terminate it. So I'm not going to let one party use the cross-examination technique to basically intimidate the others or to basically obtain some advantage that way. However, questions which go to settlement are proper, and they're important, and they should be permitted. And one thing I tend to do as a mediator is I ask the questions. Then I turn the floor over to the lawyers, and if they want to ask questions, ask away. But I get to play communications control.
You know, I'm going to ask a question which will help wrap us up. The critical aspect, as Gary and I found last week when we were doing a mediation together, is writing it up. What are your comments on writing up the agreement at that point and not letting counsel walk out and say, well, we'll call each other and work on it?
I always insist that we write it up. And I go a little step farther for those of you who've done it at my place. I have a computer. We type it up. We type it up cooperatively. I go in, I do the handshake, congratulations, you got a deal, go have a smoke. Lawyers come with me, they sit in my office, and we bang out minutes of settlement. And that is absolutely critical. Every single time, it's like, I'll get back to you on Monday, it falls apart.
My mediation agreement provides in it that there is no oral agreement. Unless the mediation agreement is signed then and there is no deal. Nobody leaves my mediation dragging me into court as a witness as to whether or not there was an agreement or not. The involvement of the mediator in the drafting of the deal, I think, is a legitimate use of the mediator.
What if one of the parties is wavering so badly, you're concerned that they're going to, at the end of the day, if they sign it, be very upset the next day? Do you have them sign it, or do you not have them sign it?
That's a very good question, Howard. I've seen circumstances where the parties ask for a 24-hour cooling off period. The other side says, well, if you don't sign now, there's no deal. Well, if there's no deal, there's no deal. You want the deal to be durable. And you don't want to, be faced with a claim later on that the client was coerced into a deal that they wouldn't consent to. And if somebody is expressing that, it's a very good point, Howard. I put it right on the table. Let's make the deal durable. Let's have a 24-hour cooling off period. Both of you go away and think about it.
I don't know. To me, that's mostly the counsel's problem. It's not necessarily mine. If he's stupid enough to let his client sign a deal, he's going to be the one sued, not the mediator. And that can often be a tactic by one party to try to get a squeeze out of the other. So as a mediator, I turn to the lawyer and I say, well, if you feel your client's competent to sign today, fine. And if the other side says the deal's off the table, I may go, why? If it's good today, why isn't it good in 2 days? But some people use the timeout as a bargaining technique. And they come back the next day and they just want to squeeze a little bit more money out of it. So I just see that as another tactic used by people in tough negotiating. And I think if you right away assume that the poor troubled person is weak, then you're playing into that game. That could be part of his or her tactic.
What we're talking about here goes to the heart of mediation theory, and that which is founded on 2 fundamental principles: mediator neutrality as well as objectivity. And of course, everything that Barry and I have been saying seems to go against that principle. And if you read and I think there's a large dissonance between a lot of what you're reading on mediation advocacy, of which there is very little in this province. Barry wrote a book. There's a couple of other books around. That's which, yes, that Barry, which you should read. But we haven't yet developed in this jurisdiction theories of justice, theories of advocacy. Many lawyers feel very torn in a mediation about what is their job there. Are they there to champion rights, or are they there to make a deal? And what kind of deal? And is the deal right? Is it fair? And how do I know if it's fair? I mean, are we simply trying to predict what would happen at a trial anyway? You as advocates have some ethical dilemmas actually in mediation that mediation theory throws at you.
That was very, very interesting, and I wish we could go on longer. And we're going to have to, Barry and I will have to structure in future years more of these sorts of dialogues throughout the day, not just at the end. And that was very helpful of it, and we thank you for it. But we're going to have to be back at exactly 1 hour from now to resume, so we have to cut it out now. But
thank you very much, guys. That was great, guys. That was great. That was great.
No more than 2 minutes.
But like
That was really good.
Like you and I
Very
said,
good.
we knew exactly what the deal was. And we did.
You know what?